You think if you got this going on, you're free to go? You're not free to go.
Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts, where I, your very own personal board-certified criminal defense lawyer, is here to inform, entertain, and otherwise make sure that you have the information you need so when you go to a cocktail party, you can be smarter than everybody else in the room. I'm coming to you with my pearl handle pistol cufflinks, which were so graciously gifted to me by our content genius that you knew as Michael Rivers, that give me the intellectual wisdom to carry on. Now, today we're reacting to just some updated information about Luigi Mangione. Now, if you remember, he's the suspect who has been apprehended and charged with the murder of the United Healthcare CEO. Now, this presents an issue of Miranda. What is Miranda? Miranda is the warning that the Supreme Court says that when you're in custody and there's interrogation, police must issue before any questioning. So if you're in cuffs and they say you're detained, you're arrested. I mean, fucking detained, arrested. What's the difference? But if they're trying to take your statement while you're in custody, they have to Mirandize you. And guess what? If you, in fact, say that you want a lawyer, they have to cease all questioning. They have to. And anything you say after that point, if they elicit any response from you, that has to be suppressed as what they call fruit of the poisonous tree. So whenever there's a violation of the law, there are sanctions. And generally speaking, where you have, like, for example, if they enter your house without a warrant and there's no exception to the warrant requirement, what is the remedy? Is it throwing the case out? Not necessarily. The remedy, then, is to suppress whatever the fruits of that illegal activity are. For example, though, if they search your house without a warrant and there's no exception to the warrant requirement, and it's an illegal search, if the court finds, and what you do is you have a hearing, you file a motion to suppress, then you put the cop on the stand, and then you cross-examine, and then you write briefs afterwards, and that's kind of how the whole process works. And if the court rules that it was an illegal search, then the results of the search are fruit of the poisonous tree, and they are suppressed. Now, we have some information. So let's take a little bit of a look at what his lawyer said in that last press conference. We already kind of went over that a little bit, but let's take a look at it and see what the new information is.
Hundreds of them, and we have not received those yet. Very important. We've also just today received the discovery regarding the arrest in the Altoona case, and we've received a little of that previously, and we are concerned that Luigi's constitutional rights were violated in Pennsylvania, and there are serious search and seizure issues that will be litigated in that case in Pennsylvania and in this case here and in the federal case, because it is alleged that Luigi had a gun on him and had other property on him that they are going to use against him in all of the cases. And if there is a search and seizure issue, and again, we have to review all of the paperwork and camera footage when we receive it before we say definitively whether we think there is one. But so far, what we are seeing is we think there is a serious search and seizure issue, and so we want the opportunity to litigate it, including in Pennsylvania, where he was supposed to have a court date on February 24th, but the Department of Justice.
So she's basically saying that there are some legitimate search and seizure issues with regard to what happened there in Pennsylvania. And so let me tell you what we have. So according to some breaking news disclosure by the Luigi Case Files, it's on Twitter or X. Breaking news, according to a motion filed today by Luigi Mangione's Pennsylvania attorney regarding his arrest at McDonald's in Altoona After almost 17 minutes of unlawful detention and interrogation, Officer Fox of the police department finally read the defendant his Miranda rights. At the conclusion, at the reading of the Miranda rights, they asked him if he wished to speak, and he shook his head no. Officer Fox immediately stated, "You are not in custody." The statement was materially false, inaccurate, and contrary to the law. The defendant was in fact in custody, and in fact had been in custody since his illegal and unlawful seizure and detention. Now, I'm not going to get into whether he was unlawfully arrested or not. If he's at the McDonald's and somebody identifies him as the person that was witnessed there, was it illegal to detain him? No, it wasn't. Even for a brief period to find out who he was, it's not illegal to detain him. What happens is, because what do you need to detain somebody? What do you need to stop somebody? Reasonable articulable suspicion that a crime was committed. And somebody says, hey, that's the guy. So they have a reason to believe that that person is the person of interest in that other case. Now, to arrest him, you need probable cause. Just that it's more likely true than not true. It's really not that high of a standard, to be honest with you. But it's more than reasonable suspicion, but less than reasonable doubt. And so, if in fact he's in custody and Miranda's not being read, well, you can't use any of the statements that he makes, while he's being detained. What's more is the minute that he asks for a lawyer, you have to seesaw questioning. But here's the thing. What is the remedy for that? Is the remedy to throw out the whole case? No. The remedy is just suppression of that statement. But guess what? If he testifies, that statement still comes back to haunt you. Because they can use it to impeach after that. That's the law. And when you watch this, it's interesting because these fucking cops know what's going on. And this is black letter law. I mean, it's not like it's even a question. Although with our new Supreme Court, who knows what the hell they're going to do with Miranda. I bet you any money they attack Miranda. But in this case, these are overzealous cops who just want to get a confession so fucking bad because they know if they're going to be heroes if they do. And they skirt around there. Oh, by the way, you're free to go. You think if you got this going on, you're free to go? You're not free to go. And so that's false. It's misleading. It isn't. But see, if you are free to go, Miranda doesn't apply because you're not in custody. But if you have fucking handcuffs on and you got 17,000 cops around you, your freedom of movement is restricted. You're under arrest. And had he ever left police custody? No. So he wasn't. And why would a cop do that? If I was a DA or a U.S. attorney, I would just light that motherfucker up like nobody's business. What the hell are you doing? You're destroying our case. And then, was he armed? You take somebody into custody, they can search you for weapons, for officer safety. But can they search your backpack? Good question. You take the backpack away, and this guy had a manifesto. This guy had all kinds of, he was a dangerous guy, no question about it, because he just cold-blooded killed somebody on New York City streets. But if you look at this deal, what are they going to do with that backpack? The smart thing to do is get a warrant. Get a search warrant for the backpack. How quickly do you think you could get a search warrant for that backpack? In like 8 minutes, right? So we have somebody that's identified as the shooter in this case. We'd like to search the backpack, judge. Okay. And then they fill out an application for a search warrant. Basically, it's a one-page document. Here's why we believe evidence of a crime might be found in that backpack. And it's temporal. In other words, it's a timely thing. So how hard is that to do? How hard is it to do things the way you're supposed to do them? Not hard at all. How much can you fuck a case up if you don't? Look at Mark Furman in the OJ trial. He lied on the stand, and that destroyed the case for the defense or for the state. So they just filed this motion to exclude evidence. So Thomas Dickey, who is his defense lawyer, he's representing Mr. Mangione. He filed a motion to suppress the evidence against the 26-year-old, claiming that Altoona police violated his rights and they illegally detained him. Let's see. In the 23-page filing. What the hell? Usually these filings are fairly short. He alleges that Altoona police cornered Mangione inside of the restaurant and would not allow him to leave under his own merit. According to the documents, Dickey alleges that the police never told Mangione that he was free to go, and that the officer reportedly provided no explanation for the encounter other than stating that he had looked suspicious. Dickey further alleges that the officers continued to legally question Mangione inside the restaurant, at which time they reported conduct and an illegal pat-down. The motion also claims that the officers never read Mangione his Miranda rights, which, if true, is a direct violation of the Constitution of the United States. Here's the thing. If he didn't give a statement, which I bet he didn't, if he didn't give a statement, it's of no consequence. Because what is the remedy? The remedy is suppression of the statement. So one of the things defense lawyers do is, sometimes we just file motions because we preserve the client's rights. My guess is that this lawyer, Mr. Dickey, probably hasn't had too much of a chance to really talk with Mr. Mangione. So he's filing this motion. And you can always withdraw the motion. But so here's some of the motions that they filed. The defendant believes that the instant charges are not supported by a prima facie case, so that the petitioner's detention or confinement on the instant charge is illegal. Petitioner avers that any evidence seized or obtained in the possession of law enforcement and or the Commonwealth purportedly in support of any instant charges would obtain illegally. So, in other words, an illegal search. Petitioner is not restrained herein by virtue of a sentence after conviction. That's probably true. The privilege of a writ of habeas corpus is now suspended. Blah, blah, blah. Just all this. And here's their motion to suppress. On or about December 9th at approximately 9:29 a.m., defendant was approached at McDonald's located at 4007 East Plank Road in Altoona. Said uniforms exhibited badges. So the people were approached by law enforcement. Defendant was seated at a corner dining table that had a wall directly behind him and to his left. There was also another unoccupied chair to his immediate right. Defendant's only natural path, so in other words, he was restricted of his freedom. Upon arrival, Altoona police officer immediately posted himself to the right of the defendant and within approximately arm's length of the defendant. This action taken in order to detain and or totally curtail the liberty of the defendant and to restrict the defendant's path of travel ingress from the table where he was sitting. These actions were performed clearly to exhibit said officer's authority. In other words, he was not free to go as the officers might have alleged. No explanation was given to the defendant relative to the police approached to why the police approached him at McDonald's. They don't have to tell you why. At most, police indicated that he looked suspicious and that he had overstayed his welcome at McDonald's. It is stressed that the defendant was being detained, and other than that, he merely had overstayed. But see, all this doesn't fucking matter if he didn't give a statement. Let's say that this initial encounter was somehow illegal, which it's not illegal. But let's say it was illegal. Well, then the identification, the firearm that they found in his backpack, and all that other stuff gets suppressed. Doesn't mean that the charges get suppressed. But my guess is that a judge is not going to grant this motion. And in large measure because, if you take into account that somebody at McDonald's said he looks like the guy that was involved in this case, right? And so, is it reasonable and articulable suspicion? Yeah, because somebody said he's the guy. And then they're able to detain him for that reason. But once they do that, they have to read him his Miranda rights. They just do. But we'll see what happens here. We'll follow this. My guess is that, this is probably going to fall by the wayside, although there is a misleading statement made by the cops, apparently, where the cops say that he was free to go, and that just isn't true. And here's the other thing. So approximately 15 minutes had gone by while they're investigating to see who this guy is and if he is, in fact, the person, So the initial encounter, you don't have to. You can detain somebody initially just to do a quick investigation to determine whether or not somebody is the person that they're saying they are, whether they are the person that's involved in this crime. And so that initial detention and initial questioning is not protected by Miranda. However, once he's arrested, once he's now fully detained, anything he says has got to be Mirandized. It just has to be. So we'll follow this. And are there issues here? Absolutely, there are issues here with this cop's conduct, if proven true. But it isn't going to toss out the case. It isn't going. I don't think the firearm that was located in his bag, I'm not sure, but I don't think it was the same firearm that was used. Different caliber is my understanding, but I could be wrong in that. And if it's not, it just, I don't. Even if it is, I don't think they need that firearm to prove their case. But if I'm a prosecutor and this cop fucked up the search of that bag, I'm pissed. I'm really pissed at these cops. And if I'm a defense lawyer, properly, filing in my motions, doing everything, I pounce. So we'll see you next time here in Criminal Lawyer Reacts. This is just a quick update on Mangione and motion filed by his Altoona, Pennsylvania lawyer about suppressing evidence. And make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for a Patreon as well. We'll see you next time here in Criminal Lawyer Reacts.
Charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away.